So it is a speed debate today, so I am going to get straight into things with our debate number one. And debate number one is headed, mediation should be a mandatory prerequisite to arbitration. So affirmative, as in who will be supporting the motion, we have Rhys Monahan, Senior Associate of Reed Smith, and against the argument will be Joe Durkin of LCM Finance. Rhys, over to you.
Thank you very much, James. That's good level. Actually, that's really good news for me, because if I get one person to move the other way, that's good news. So, I think we're all here this morning quite early, so thank you very much, everybody, for attending. I want to start off describing a little bit about what mediation is. Then I'm going to go into the benefits of mediation, 3 points, and I'm going to go into the 3 reasons why I think that mediation should be a prerequisite, and then I'm going to do some concluding remarks. Obviously, it's a difficult room. We've got a lot of people with vested interests, perhaps, in continuing disputes, but without further ado. So the UK Government Guide to Civil Mediation says that mediation is a flexible and confidential process used to settle a dispute between 2 or more people, businesses or other organisations. It involves appointing a mediator, who is an independent and impartial third person, to help the parties talk through the issues, negotiate and come to a mutually agreeable solution. I think one thing missing from that definition is the term voluntary. And today we're going to talk about the three things that, as I've noted, they're the benefits, 3 things that are the reasons why I think it should be changed, and why you should vote for my motion. And firstly, as noted, I'd like you to put yourself in the position of the client here, who obviously has a number of concerns, including costs, timing, and other issues. I'd like to, and it's the principle of this motion, not necessarily the execution. So, the benefits of mediation. I think this is probably the biggest argument for this. It's got a high success rate. So, in the UK, the Centre for Effective Dispute Resolution, or CEDAW, in its 2021 report, which I've got over here, and you guys should really read it, indicated that 72% of mediated cases were settled on the day, and 21% shortly thereafter. So that's 93% settlement rate. That's fantastic. You're not going to get that in any other real form of dispute resolution. Secondly, reduces time and cost. Mediation is a more cost-effective way of resolving dispute resolution. The Centre for the CDR says that most mediations can be settled within 10 hours. So you can resolve a dispute within 10 hours instead of a year, 2 years, then enforcement. That's fantastic. And the same report indicated that mediations save the process of mediation, instead of going through arbitration and formal litigation, saves up to GBP 4.6 billion a year in wasted management time, damaged relationships, and lost productivity and legal fees. That's huge. And finally, on benefits, parties have got degree of control, the flexibility of the process, and the eventual remedy. So one of the key benefits of mediation is the fact that parties are in control. You can decide how it's done, you can decide who the mediator is, you can determine what the issues are and how you're going to do the process. Yeah, so that's fantastic. And then moving on to why should mediation be a mandatory prerequisite to arbitration. Now these are a little bit more controversial in some ways, and I think this might generate a few questions at the end of the debate. So the first point, organisation of disputes. A mediation process can allow parties to come to terms on various issues where there's an agreement on, and then proceed to arbitration with only the highly contentious issues. So you can get things that are, for example, the factual issues or the small issues in a dispute out of the way. You can deal with those. There's so many occasions in which a nuanced point about a particular fact will be dealt with over weeks of correspondence between parties or in submissions, when actually that whole process can be dealt with pre-arbitration. So the arbitrators are only looking at what issues are in the law and the really contentious points. Having the opportunity to go through mediation also allows parties to review their own claim, see what the risks and the rewards may be, and also, importantly, review what the other side's claim may be and the strengths and weaknesses. So you can find out how strong both sides are. And finally, the organisation reduction in costs also helps level the playing field. There's so many situations in which two parties are unequal in funds and in resources, which often means that one party is represented by a number of QCs, and another party has to deal with the situation with its in-house counsel, or even deal with it themselves. The second point, maintenance of the relationship, control of the process before the point of no return. So mediation, as it kind of indicates, is an opportunity for parties to discuss things in a commercially sensitive way, and it's less adversarial. Mediation can allow parties to continue their commercial relationships before you get to that point of no return. When you start arbitration proceedings, when you start litigation, you are going to get more confrontational, more adversarial, which means that really there's a diminishing chance of you continuing that relationship. There also might be things as part of that process, the further along it goes, the more orders you will receive, you'll have to go through the disclosure exercise. Do you really want to go through that process and have everything laid bare on the table? Perhaps, that's when you've lost control and you're railroaded in the system. And then finally, mediation, it's been talked about as something that might be the future, but actually mediation's a lot older than arbitration, or formal arbitration. So even in this region, there's excuse my pronunciation, there's al-wasata, which has historically been an integral part of dispute resolution in the Middle East. And in addition, in the Middle East, there's the rituals of sulh and masala, which is settlement and reconciliation. So parties here are much more familiar with the process of mediation than arbitration. Going forward, in the future, there's a lot more encouragement from parties, governments and organisations for parties to settle their disputes before they get contentious.
Thank you, Rhys. Mr. Durkin, against the motion.
Yes, thanks very much, Rhys, for that introduction, and thanks obviously to Reid Smith and for Sash as well for inviting me here this morning to contribute to this debate. From a starting point, I agree pretty much with most of what Rhys has said in terms of what mediation is about and the utility of it. And I'm a fan of mediation. One of the first jobs that I worked on as a trainee solicitor many years ago in Dublin was to help an Irish businessman, a tycoon, who had a dispute over a stately manor, and the opponent was the widow or the estate of a builder. And after 3 days of mediation and talking about such technical things as extensions of time and variations and disruption, I think it was in the last 20 minutes, around 3:30 in the morning, that counsel whispered into the tycoon's ear, "If you don't settle this dispute, the Daily Mail will be talking about it tomorrow, and they might say, builder screws, widow," or something to that effect. So that was probably one of the things that maybe you weren't able to get across as easily in correspondence, or maybe it was the fact that he actually took sympathy on the poor widow. But I've seen mediation being used effectively, and I think that the motion being that it should be mandatory in arbitration is relevant and important. I've been provided helpfully with some research notes, and it's not the first time that I've looked to Reid Smith for some sort of intel when it comes to arbitrations and whether there are pitfalls in mediation. It was one of my go-to articles when you'd fill a bundle in an arbitration to argue the point that the mandatory requirements for multi-tiered arbitration clauses in the Court of Cassation set out clearly that if you don't follow to the letter the process, that you're going to end up with a potential for nullified arbitration award. And this is, I suppose, something that I want to have a little bit of a starting point or touch on, and just put two scenarios to you in the context of mandatory mediation and arbitration. If I was to tell you that there's a developer in this part of the world who by design puts into his arbitration clause a DIFC LCIA arbitration clause for a 3-member tribunal, knowing that arbitrators charge out 2,500 dirhams per hour, and knowing that there's a level of unpredictability in what the advance and cost is going to be in the mechanism that's employed by that arbitral institution. And if I was to say to you that part of his thought process was, well, if a buyer of a 1-bedroom apartment was to spend 40,000 dirhams in court, would he be more reluctant to come after me having to pay 150,000 dirhams in an advance plus more? And if he was told that a mediation clause is just an extra hurdle for those potential customers to go through, would that be an attractive proposition? And if I was cynically minded, I might think that that's precisely what his general counsel, who told me over a drink, is the way they go about putting these clauses together. So, in short, mediation is being used frequently to elongate, to make the process more expensive. And if we look, let's say, more closely to what we are involved in, let's say, construction disputes, and you simply think of the scenario where you've got, for example, a contractor, and he's afraid that the bond is going to be pulled. Maybe he knows that other suppliers to the same main contractor have had that situation happen to them, and he files in the Dubai court for a freezing order and gets it, and it is advised by his lawyers that he's got 7 or 8 days to file substantive proceedings. And if he doesn't do so, the freezing order is lifted. Where does mediation sit in that entire scenario? He can't go to mediation because he's raised a red flag that there's a dispute on the horizon. He's given the hint to the opponent that he's already put in momentum that actual multi-tier dispute resolution clause. So he leaves himself in a pretty much catch-22 situation. And from a practical perspective, I suppose this is what I've seen. I've never seen in 13 years as a disputes lawyer or as a third-party funder, sometimes what we're called as glorified ambulance chasers in pinstripe suits, but in 13 years I've never seen a situation where I've said, wouldn't it have been a real game changer if we had a mediation clause in that contract? That hasn't come about, and I think if I put a show of hands to the audience as lawyers, have you thought similarly? I suspect that a lot of you have shared the same view as me, where I have come across situations where there is a mediation clause. I come to a view that it causes more trouble than it's worth, given that it is a voluntary process and you can trigger it whenever you want if the other side is agreeable to it. And that example of bonds and construction contracts is just one example where it becomes troublesome. Multi-tiered arbitration clauses, and mediation is just one of those elements of the multi-tiered arbitration clause, has led to a graveyard of nullified arbitration awards. And my experience has led to at least us as third-party funders turning down disputes where we see potential jurisdiction challenges on the horizon. And quite often what we will say is, if there is a defect in terms of how you've approached the mediation, come back to us after you file the arbitration. We'll see if there's been a jurisdiction challenge and how did you get along in that. And that's just something very practical in terms of what we're seeing. And then I suppose the other point maybe to note really is that the voluntary nature of arbitration and mediation is such that we're not stuck like in some places that we have to go to national courts. There are several arbitral institutions we can choose to go to in this part of the world. There's one less than there was before, but there was several and there still is. And if I don't like what the rules say and I want to prefer one over the other, I know where Abu Dhabi is, it's an hour away. I know that London is a 7-hour flight, and as is Singapore. And if there was a requirement for a mandatory arbitration clause in a contract, I might just call up my colleague Roger in Singapore and say, I hear SIAC are doing a pretty good job over there, and we've always liked London as a seat, and we quite like what the LCIA or what the ICC do. So you can see where I'm going with this. The users of arbitration are using services, and the arbitral institutions are service providers. They're fungible. We can go wherever we want. And as third-party funders, we put them in our contracts, we get behind disputes, we voluntarily walk into those situations. And where we see mediation clauses, I've never actually thought that I'm going to price the job at a lesser price because it's a mediation clause. I cynically haven't seen mediation work frequently enough in this part of the world for it to give me a view that it's a worthwhile process. As I said, it causes technical difficulties more often than not.
Thank you, Joe. Thank you, Rhys. Thank you, Rhys Plants. Excellent. Debate number 2, and that is headed, Document disclosure in arbitration is not fit for purpose in a civil law jurisdiction. And speaking on this will be Alison Eslick from Rhys. And thank you very much to Yusuf Al-Melmi from Email Properties. Okay, excellent. Best of luck, Yusuf.
No, but just let's think about this from an in-house perspective, right? Whether you hate to lose or love to win, it really doesn't make a difference. Your goal is really winning the arbitration. So it doesn't matter what you do, you have a board to answer to, right? So I just would love to have this discussion in a debatable way, the same way I do it with my lawyers. And when I say my lawyers, I'm speaking about my lawyers in the UAE, in India, in Pakistan, in Egypt, in Turkey, in Saudi Arabia. And I usually have two kinds of answers. It depends really on the background of the lawyer who's answering me, whether he's coming from a civil law jurisdiction or he's coming from a common law jurisdiction. Now, my civil law jurisdiction lawyers would usually answer me saying that, okay, you don't have a legal obligation really to disclose, but it's a best practice or it's a preference really. While common law lawyers, they have this concept where it's usually acceptable and it is in their law, it is in the blood of the lawyers, so they have professional rules that mandates them to disclose everything to the tribunal. Now, I always ask my lawyers again, why should I disclose? And I get either of those two answers, so I start rephrasing my question again. What happens if this hurts my case? What happens if because of disclosing everything, I lose my case? I get the same answer. So I rephrase it for the third time and ask them, would you really give me an insurance and confirmation if I disclose everything? I'm gonna still win this case. That's the moment of silence. Nothing, right? Because eventually, I know lawyers, whether they hate to lose, love to win, again, they will do professionally what they have to do for the best interest of their client. But I have a board to answer, and I would love to ask Alison the same question. Why should I disclose the documents knowing that whatever sanction, whatever kind of punishment I would get of not disclosing everything would just be limited to money? And when I'm speaking about disputes, I mean, I should have started with this. I'm not representing my personal opinion on this, and I'm not representing the opinion of my organization, but whatever I have to disclose, would you really believe that there should be, or there will be a kind of punishment that I would receive, or a fine, or what is exactly the limitation, or what's kind of the worst case scenario that will happen if I lose my case? The answer I usually get is really, I mean, and we are talking about the civil law jurisdiction, right? But even for a common law jurisdiction, my lawyers would tell me that, okay, and I don't want to quote which lawyer, but they would usually say, okay, if you don't want to disclose this, don't let me know about it. That's how they phrase it.
What approach?
Yeah, yeah, but again, I do. Yeah, but again, this is really. I mean, you have to understand that from an in-house perspective, it's a total way of managing things. Now, lawyers in private practice, and I come originally from a private practice, I do understand the obligations, the professional conduct rules, and what we have to do for our clients. But as an in-house lawyer, the two things are totally different. My neck is on the line. The board, when we are talking disputes, I'm not talking about small claims of 1 million, 2 million. I'm talking about hundreds of millions of US dollars and billions of US dollars of claims. So whether it's in relation to construction or relation to any kind of other shareholder dispute or whatever kind of dispute, it's still a lot of money at stake. And my board would not understand why did I lose the case, because I had an obligation of disclosing a document that really hurt the case or made me lose. So this is in a nutshell how I would phrase it, why I shouldn't disclose a document. So
Yeah, that was great. Thank you, Yusuf. Alison?
Okay, first, thank you very much to Yusuf. I think there was a lot of authenticity in what he's saying, and I think a lot of the in-house counsel probably will relate to a lot of what he was saying. However, I am arguing for the negative, and my team line today is that the overriding purpose of document disclosure is to help an arbitral tribunal find the truth. Now, the process isn't perfect, but it's fit for purpose, and it is definitely here to stay. Now, over the years, we have occasionally heard cries from legal commentators in the legal community that disclosure in arbitration should, for want of a better word, be cancelled. And we even saw the Prague rules in 2018 introduced with much fanfare. And these contained quite a limited, more civil law approach to disclosure. But the fact is, after all the initial excitement of the Prague rules, these seem to be a bit of a fizzer. And I will ask, just for a quick straw poll, who in the room has had an arbitration subject to the Prague rules? Oh, we have one. Yeah, and that's what I'm saying. So I think that disclosure in arbitration, and I'm talking about the broad category type of disclosure, it's alive and kicking, and I believe it's here to stay. So I'm sorry about that, Yusuf. I think there's three main reasons for this. The first one is that for an international arbitration, even in a civil law jurisdiction, disclosure is perfectly fit for purpose. Now, understandably, as Yusuf's explained, parties from a civil law background may be very wary about an arbitral disclosure process because it isn't part of their legal tradition. But in places like the UAE, there are a melting pot of nationalities here doing business. So parties from civil law and common law backgrounds, they've got to meet each other halfway in their arbitration procedures. Accordingly, in almost all the arbitrations I've been involved in, the IBA rules on the taking of evidence in international arbitration, or rules very similar that have been put in a procedural order, these are the ones that have applied. Now, these contain a format for disclosure that is, it's far narrower than a US pre-trial discovery type of process, but it's also broader than a very specific document request, as you see in a civil law court system. And by allowing requests for documents that are not only relevant but are material to the dispute, the IBA rules, I would say, strike the right balance between the common law and civil law systems. Now, the statistics also show that document disclosure, isn't quite as unpopular with in-house counsel as my esteemed opponent, Yusuf, might have you believe. In the 2021 International Arbitration Survey, although 31% of in-house counsel, like Yusuf, said they were willing to exclude the document production system altogether, the overwhelming majority of 69% were actually fully in favour of that process, which I believe supports the motion that it is fit for purpose. My second point today is that the disclosure process isn't perfect, but its benefits do outweigh its costs. So we know that disclosure costs time and money, so why do we bother? And look, first, as corny as it sounds, justice. Whilst parties can instruct the best lawyers in town to represent them, in the end, evidence is what a tribunal is looking for. And a disclosure process is worth the cost because it levels the playing fields between parties. It keeps the parties honest. And it ensures the arbitral tribunal has as much evidence as needed to fairly decide the case and to issue an enforceable award. Now, the second benefit is cost. So you just heard me admit that disclosure costs quite a bit of money sometimes. But do you know what costs more money? Pursuing a case only to find out very late in the game that you actually don't have a case at all. Actually, there are files of documents that say exactly the opposite to what your lawyers have been arguing. Now, that's expensive, guys. So, if parties know there's going to be a disclosure process, it encourages them to think up front, what are my real prospects of success here, based on the evidence I know exists. And if your case is a rotten egg, then just settle and move on. So the third benefit, again, is...
Can I respond to that? It's going to be just in 1 minute. So I would tell you even what's more expensive, losing the case. So that's very expensive. That's one. Again, I'm sorry.
Give me back. Okay, well, we'll move on.
Structure's just gone out the window.
Yeah, we'll move on. So the third benefit there is, it's again cost. And I'm going to say this because sometimes cases just can't settle, they won't settle, it's just not going to happen. But a disclosure process can still benefit things because it really can help narrow down the issues in dispute. It allows the experts, the parties, the tribunal, everyone to focus on what's really important. And it can make the outcome of a case more predictable, which helps businesses assess their level of risk and assess their level of investment in the disputes process as it goes forward. Now, we have heard from Yusuf that parties from civil law backgrounds will rarely, if ever, hand over a smoking gun, either to their external lawyers or to the tribunal. Now, look, most arbitrations worth proceeding with involve complex projects and transactions. And liability, I would say, rarely, if ever, boils down to a single document. The idea of the smoking gun, it might be the reality in an episode of Suits, but, in real life, unfortunately, my line of work is much less dramatic than that. And anyway, even if a document looks really bad, a good strategic lawyer will often find a way to argue around it.
I can't respond to that.
Okay, so I'll move on to my final point and then you'll definitely get a chance to respond. So my final point for today is that, look, there are enough checks and balances on a disclosure process to keep the parties honest. Now, I can't deny Yusuf's claim that the sanctions for non-compliance for disclosure orders lack real teeth. But query whether sanctions such as jail time or expensive fines would really be appropriate in an international arbitration setting. I mean, sure, we might get full compliance with disclosure orders, but I dare say parties would reconsider, the need to really be in an arbitration if we were going to go down that route. And in fact, there are multiple layers of protection for the integrity of the disclosure process. So first, tribunals are smart. Well, that's why we hire them. And they don't like being lied to. So if a party refuses to hand over documents which are reasonably certain to exist, a tribunal is going to notice this. And in serious cases, they will draw an adverse inference that the document, if produced, would be harmful to a party's case. And this can really strike a serious blow for a party's credibility. And it might actually be worse, I would say, than producing the document and just dealing with it. Now, second, external lawyers, as Yusuf mentioned, we do have our professional obligations, and these are serious, and I believe they do provide a proper safeguard. And finally, I have seen tribunals require parties, general managers or CEOs, to actually sign a detailed declaration about their document searches, saying, what they searched for, what they found, what they didn't find, why they didn't find it, what's their document destruction policy. And, I do believe that it's much harder to lie to a tribunal, when you have to sign on the dotted line. So I think that is another safeguard.
Okay, I think that's going to conclude our debates for today, debates 1 and 2. So thank you very much, Alison, Yusuf, Rhys, and Joe, and thank you all for attending today. Thank you, organisers of Arbitration Week in general, and thank you for Elise for setting us up in the first place. Thank you very much for coming. Great to have you.